Ebusian de kwan so ma mencha na memo akwa abasronko emfa umra possible multimedia. Eni de kwan so ene ne de kan we ya channel is YouTube and sa edan sai me be so be jebre. No hwe video no amana kwa we so hwe ya no like wa comment wa subscribe we ya no share content no and also recommend the channel no ama unu ebi so enya videos ni bi ahwe aha no mama ya we say amanyon semo a etwa gu wo man konkron Ghana mo edi kan edi tie no eno ena mo som for Francis Achu anytime any day a ebi ebe drop e social media no na ya drop nsem no mo esuko anase di asem na chi akọhwe no kran bi na edi bi aba be som e wo possible multimedia me so ne so my say aha ye ni atem ya dwen na che based on what you see and hear on social media ebusuan for some time now my year report bebre e dia fa ye papa anase yin na ye penny honorable ato forcing ambulance issue no ho mpempe ya me no ka say di asem no e wo court asem nso so e wo court na se wo ka ho asem na wo kira wadwen e wo ho na se wan kan yi a court for e wo terms bi a ya to ni din contempt yes bushie mpempe ya me no ka say di her lordship ye ma me efu asewa ede na no di isem abato abonten say Oduna eliki ya ema NDC for adwen ye omo say Attorney General enim the whole issue ni hu bi no wagye atum say NDC for anase honorable ato forcing any lawyers enfanye omo evidence anase omo mfa enka omo evidence ho until time e wete Attorney General anu di isem anase ni ntiremu say e bia voice no enye me voice bia eye mea ne momi wo sei eni sei ena eka e de fa ho abusia until then ye maame efose wa her lordship agye atum say wo mo fanka wo mo evidence ho na me pese me kasa ne be tenten no hye ne say aha possible multimedia yanko na yenya nsem ni mu nchemu ankasa ye de bi e ba be so mo we fidie kati so kame ho ne na ye mum enku
now ewia ni mu ena justice efia sewa asarebotwe the ruling ebeto abonten ya na o kire say the audio recording has been admitted into evidence in the ongoing ambulance trial. The odi batwi kasemu a de me pa kire ne say awianemu ena justice efia se wasarebotwe ya oye judge ni a ote ambulance case no so ka say sa audio recording no a MPP NDC case lato forcing the Attorney General Twe ne sreni abasa no enedie yagye atum se emeya dansidie ewo ambulance case a ekoso ewo the Accra High Court na nipa bebrebe adwene eyi omo na ase enti ena on this same recording the learned Justice Efiasewa Asarebotwe ebetu just said there is not enough evidence in the tape to make a decision say the Attorney General was trying to implicate Casey Latofos and use Richie Jakpa into order dismissing Miss Triano. Now for the DNS Sentia and the Justice of Yasawa Celebrity admitted the audio recording as evidence. Now, what do I need to know? The law platform. Lawyer for Yajba Honomo, Edgy and Chilemo, Eddie Free, the higher court, Omode. And some not talk for Bonina about with an affair so no cross examination ya ene due e chassis e wa Accra High Court won so omo de won sem abanti e bekom na ya chichim kakra enti no almost a law on admissibility of evidence emra eboa amaya ji bebi atum se emeya dansidie no se na mra ne ka almost say her ladyship Justice Efiasewa Asarebotwe gave an exposition on the law regarding admissibility of evidence per the Evidence Act and highlighted the application of the famous Kubaji versus Asare and others case. Kubaji case on breaches to privacy rights. The court said that the present case is a reverse scenario in the Kubaji case and same has applicability to the present case. Enti Justice Efiasewa Asarebotwe emma yemfato ho adekodienti awoje audio record ni tum se eme adansedie ewo case na eye Kubaji versus Asare and others na wo chirim se ukohwesa case no a na Your breaches to a privacy right. Name no court no ejina emra ahodo so. J an audio recording to mo any case a ekoso ewo the Accra High Court eno no pepepe. Now let's look at the admission. Was a Justice Asariboche per her ruling admitted the audio recording subject to wait to be placed on sale by the court. Her ladyship heard that the conversation on the tape has not been denied by the Attorney General and that there was the need for reciprocity as the Attorney General would have had its evidence admitted if same was procured by breaches to privacy rights. Her ladyship in her ruling drummed on the provisions of the Electronic Transactions Act 2008 Act 772 and the permission it allows for the admission of electronic evidence subject to some exceptions. Enti ahano na Justice Efia Sewa Saribotwe her ladyship enchiremu ana wode ma ne se de edi kan ene no ayete no wasa audio recording no the Attorney General Godfrey Yebo Adame Emma Bonten emeka se enya nene enti ahono chichiremu wo ho na sa na tie nso a sa evidence sa Attorney General ne ekura no enanka wode ba as evidence nka it will be admitted said the beya nipa no a one ne mienu ne ewo tape no so no ebetubi di nchechiremu aba with regards to nkomodi a ekọ so tape ni enti no if it is against the Attorney General na ontumi me deny say conversation no enye wono ade a then e wose ye ba kwan ema nipa mienu no obi a ebo no nkuro ena her ladyship esan echiremu say okenkan Electronic Transactions Act 2008 Act 772 kwan for admission of electronic evidence subject to some exceptions. This exception be any one there. The Electronic Transactions Act 2008 Act 772 kwan se court ebeji electronic evidence ede atumu ede ayedwuma ewo court. Now caution. Her ladyship took the opportunity to caution against ambush litigation and waste of time of the court. Enti odi ruling nyina to abonti wiye no ena osan ede sa kwanya to hono se manso twen ye ehunhia ya ebesei court no adaje o case hu de enya de a ono Justice Efia Sewa Asaribotwe obesoso sokra da bi onsoso de biarada. Enti immediately ya her ladyship kasa wiye no ena cross examination by lawyers of the third accused Dr. Kesilato Forsen on Richard Jakpa on the admitted tape no eshasi. Now, ladyship Justice Efia Sewa Saribotwe can say answer na cross examination no kwabeshasi. Our question be our person Richard Jakpa through the lawyers of Kesilato Forsen or more cross examination ebe address. One, there is a commentary out there say a Justice Yoni Kulendi Supreme Court Justice and a year arrangement for that said meeting in his house with the Attorney General without the notice of the Attorney General say Richard Jakpa will be present at the meeting. And na ebinum so nam say Attorney General no request that meeting no from Richard Jakpa because say na our proud motive be say yeah there was so jelly the minority leader case Lato Force and is saying enetie enunti emma lawyers for Dr. Kesilato Ato Forsen the first cross examination question umbusa Richard Jakpa said who requested to have meetings with the learned Attorney General and Richard Jakpa say and okura pan wasem say eye ono Richard Jakpa and requested to have meetings with the learned Attorney General. And now question say how many times and now or no Richard Jakpa requested for meetings with the learned Attorney General. To pay Mr. Richard Jakpa was say he met the learned Attorney General 4 times. 4 times. And I was saying say the AG obliged him his request. A very, very interesting cross-examination, of course. Richard Jakpa ji to mu say, afedi or no mum ne request say, or pesa wani attorney general. But in all the requests, the attorney general obliged to all of the requests. And now, or no Richard Jakpa, a passing through Justice Kulendi. Or passing through Justice Kulendi, no. And because of Justice Kulendi, the Attorney General agreed a meeting with him through Justice Kulendi. And this means that the Attorney General only agreed to meet Richard Jakpa because of the learned Justice Yoni Kulendi. Justice Yoni Kulendi to me convince the Attorney General to meet Richard Jakpa through cross-examination in Yinabipi. And Richard Jakpa said, the purpose of the meeting was to allow him explain the whole story and why charges against him were unfounded. And from the narration Richard Jakpa was giving in court today, everything was about him. More to force in Diwa. To arrange that particular meeting to let the Attorney General know the entire story and that charges brought up against him, Richard Jakpa, as the third accused person, was unfounded. To try the discussion, the first accused had to force in Yemoni Diwa. And Richard Jakpa Saka said, upon the meeting, he had enough time to explain his story. Now, during the course of the cross-examination, he also made a narration of a conversation between himself and the learned Attorney General in the presence of the learned Supreme Court Judge, Justice Johnny Kulendi. In response to a question from the learned Dr. Bassett Bamba, the accused, Richard Jakpa, said he holds the view that the prosecution was based on witch hunting and political points scoring. He said, per his narration, the goal of the prosecution was also to have the seat of the minority leader and first accused declared vacant for the conduct of a by-election. That statement we and the Chichian so kakra. Because from the start of the cross-examination, we say, arrangement with the Attorney General, say, woo Jakpa. Charges are yede abobo won wo pese wo kire Attorney General say enyina so nim na fe wa kire ensem ni mu nyina de achi Attorney General wan ka atofo se ho ase wo sa ka bi on say meeting with the Attorney General was solely based on you, Richard Jakpa, and discussions about you, not atofo se enti eye den na fe the discussions are centered on you and charges pressed on you no etumi ko dane say Attorney General ni team po nyina ne say obesco political points. Now I witch hunting. Now I make sure say minority leader case lato force in the seat e declare vacant. Now for the records, emra case started case lato force na onye minority leader in parliament. He was just an MP for Jumaku Enyan Isiam constituency in the central region. Na onye minority leader in parliament. Yantu ankomonos. Now, during his cross-examination, which followed after the respected Justice Efia Sewa Asarebuchi gave her ruling on the admissibility of the audio recording, Mr. Jakpa again gave lengthy answers suggesting that the state and the present government was responsible for the state of the ambulances as they failed to follow a letter of implementation. Now, I have planned dear before Hunkran. What can kind of letter of implementation no Richard Jakpa ka ho asem no a. Letter of implementation it say 207 mini buses, Benz bus no amko kraba ye no a na ya dakato no. Na ka ye say ko India. Ako seeking for Bosnia. Edia kwakra medical equipment. Edia befitted those empty vehicles. Amanaba be ambulance. And the Ebusa say the 2.37 million euro According to the memorandum of understanding between the government of Ghana, Big C General Trading Limited in Dubai, the Ministry of Finance, the Ministry of Health, and the Ghana Ambulance Service, and him for an shemu say, yemfa 2.37 million euro no enko kraka winim na yewia ya sa kopesika foforo akokra medical equipment ya eye implementation. Only God knows where this letter of implementation is coming from. Mr. Jakpa also was of the view, per his responses to questions by Dr. Bassett, that the ambulances could not have been declared unfit for purpose, as the accessories which had to be fitted in the ambulances are yet to be cleared and fitted in the vans which were imported to serve the purpose of ambulances. And none of me children. Ti was say, MPP aban e ma kwan kwaje bosia no e ma ye de ko clear container na accessories ni gum e be hyehye no wosa empty car ni mu a enke ni ketumi ya ambulance enti no aban ya mpene ama ya nkwa clear sa accessories no am fitted those accessories into the empty vans ya omko krabaye enu nti and the ma alles segbefia e declare those ambulances not fit for purpose. This is according to narration by Richie Jakpa. Narration by Richie Jakpa. Now, lawyers for the first accused, Dr. Atoforsin, ended their cross-examination of Mr. Jakpa today. The state also began its cross-examination and will continue on Tuesday, the 18th day of June 2024. The way information kakrebi ya the law platform for Adaroma ya to me apeke a free the Financial, Economic and Criminal Division of the Accra High Court involving the ambulance case. In the end of the HDPA, states in also cross-examination Mr. Richie Jakpa. Any answers are the we are still following the law platform. Say in Sabeka that information. And Saka, you best sign their bremo on this same platform.
John, let me say 14 somewhere.
Yeah.
And scripture says, and Satan possessed Judas, and he walked out at night. That night that he was betrayed. Jesus was betrayed. Yeah. Scripture says that Satan possessed him. My question is that what has possessed John Muhammad? Yeah, what has possessed him? And I keep saying that. So